Okay, today we are going to talk about some of the different players, if you will, in international law. And I kind of break it down into four broad categories. So when we talk about the different entities or whatever that are involved with either international law making or implementing international law, that kind of thing. So at the top of the list, we have states. Now again, as I've talked about already, when I use the term state in this class, I'm referring to a sovereign country that meets the definition of statehood for purposes of international law, which we'll look at here in a few minutes. And states have historically and still are the primary player when it comes to international law in terms of interaction between sovereigns, treaty making, and that sort of thing. Number two on our list are what we call IGOs. And I want you to know that acronym abbreviation. An IGO is an intergovernmental organization. So classic example would be the United Nations or the World Trade Organization. So IGOs are international organizations that have been established by states and typically will have states as the members of the IGO. So it's a membership of sovereign states for various reasons. Maybe on a large scale like the UN, or on a smaller scale like a regional trade area like the Central American Free Trade Agreement, those kind of things. And we'll come back to those as well. Next we have NGOs, which have various different definitions, but typically when we talk about an NGO, we're referring to a non-governmental organization that engages in international activity, and typically this is going to be a non-profit of some type or a charitable type organization. Classic example would be like the Red Cross, Doctors Without Borders, World Wildlife Fund, other type of international organizations that engage in international activity. They're not a governmental unit. They are typically a non-profit or quasi-for-profit type of an organization. NGOs could also consist of affiliated sub-portions of IGOs, like a lot of the administrative parts of the United Nations fall into the NGO type category. And then at the bottom here, we have individuals. And when I talk about individuals, I mean individual people, all of us, or private corporations or LLCs. Sometimes we'll refer to an MNE, which stands for multinational enterprise. That would be like a corporation that engages in worldwide activity, Microsoft, etc. But we collectively lump those under the fourth category, individuals, meaning they're not a governmental entity, they're not an organization made up of governments or nonprofit subunits, and so they're basically in the private sector is kind of what I'm getting at. So of these, of course, next slide, states are the most important entity when it comes to international law. And historically, international law was, and still is to a great degree, the interaction of sovereign states with each other, either through conduct, custom, treaty making, conventions, etc. Historically, international law only engaged in actions between sovereigns. And what I mean by that is historically, back to this slide here, historically we didn't have 2 and 3. We didn't have intergovernmental organizations. We didn't have non-governmental organizations. We had states and individuals. And so international law only dealt with states. And that's part of, again, the theme that we've been talking about over and over again is the trend in modern international law rule of law versus rule of force, to create and put together these organizations on an international level to help try to alleviate potential military or economic conflict and for various other purposes. And that's been the trend towards the creation of intergovernmental organizations and having the organization be the driving force in international law as opposed to states having to figure it out on their own. And we'll talk more about that a little bit later. Okay, next slide. Page 51. All right, I've already talked about this. A state is the most important player in international law. It is sovereign, meaning that no other person, entity, or state has authority. It is considered to be the international sovereign in the international community. It has full legal right under domestic law to engage in international diplomacy and activity. So not a United States state. When I talk about a US state like Oregon or Idaho or California or whatever, those are not considered sovereigns because they are subunits. The states that we have, all 50 of them, are sub-political units of the United States as a whole. Our federal government is considered the international state for purposes of international law. So when we talk about states, and this varies. How many states are there in the world? Well, it kind of depends on who you ask. When I wrote this slide, it's a few years old. 195 states per the United Nations, 193 United Nations members, plus 2 observer states, Vatican and Palestine. But, depending on who you ask, there may be 206 to 207 actual sovereign states around the world. Now this changes from time to time, of course, depending on what's going on in the world. The Soviet Union, when the Soviet Union was one entity, it was considered one state. Of course, it broke up, and now we have a multitude of states that came out of the Soviet Union. Same thing with the independence movement throughout the late 1800s and through the 1900s, where you had former colonies break off from the former colonial powers, create new states, or revert back to what used to be their own territory. Same thing post-World War II, where we had Germany and all that. So this changes from time to time. And that's one of the issues when we talk about international law and we talk about sovereignty of a territory, is whether or not an area that breaks off, or, well, breaks off is probably the best term, is or has reached the level of being considered a sovereign state. Now this has a lot of political implications, economic implications as well, not to mention military. But that's one of the issues that we look at is, okay, how do you determine in international law if an area is in fact a state? If it's splintered off from a former state, it's now a new state. Is it recognized by other countries? And there are various different tests that we use for that. So let's talk about the first test I want you to know. And this is the 4-part test that comes from the Montevideo Convention on Rights and Duties of States. So these are the it's like a 4-part test that is used to determine if there's a statehood, if it meets the definition under the terms of the treaty. So this 4-part test is, first of all, you must have a defined territory with borders, and you look on the map and there is a territory that is defined. Now there may be disputed parts of the territory, but for the most part, if there's a defined territory, that's the first element that we look at, and we're talking under the Montevideo rules of the 4-part test. Number 2 is there must be a population of people within that territory. Number 3, there must be a government that is capable of entering into international relations. And so that's where the state of Oregon would fail this particular test. We have a territory of Oregon. We have people that live in Oregon. but under our Constitution, Oregon does not have international lawmaking authority. That is solely within the federal government. So that's where Oregon would fail this test. And then finally, there must be a government capable of controlling the territory and the people. So this four-part test comes from the Montevideo Convention. So let's take a look at that. It's on page 76. Okay, the Convention on Rights and Duties of State, done in Montevideo, Uruguay, 1933. Entered into force in 1934 for the United States and then other countries that glommed on. Now, why is that important? This is pre-World War II, right? So this is just as, well, in Germany at the time, this is just as the Nazis were coming to power in the mid to late 30s, leading up, of course, to World War II. So this is post-World War I, but pre-World War II. Now, the reason that kind of matters is World War II, of course, was a watershed, changed just about everything, as did World War I. But it's still in force as customary law, even if it's not considered, even if not a lot of countries have joined on to this. But with that said, this is where we get our four-part test. So first of all, under Article 1, this is where the four-part test comes in. And so, just to kind of give you some context, let's say we have a case that goes before the International Court of Justice, and the issue, the court doesn't really go this far, but let's just say the issue is whether or not a newly splintered off territory, or perhaps a territory that historically has a separate group of people that are indigenous to that territory. They declare themselves to be an independent state, Kosovo, for example, about 10 years ago, 12 years ago, whatever. And so this area declares itself to be historically, this was our area historically going back hundreds, if not thousands of years. We are now going to be considered as ourselves a state. They elect themselves a government. They have an election. And now the question is, are they a state for international purposes? And that may end up going to the International Court of Justice for various reasons. One, they may be asked by the UN to declare whether they meet the test, or it may be in a contract type of a case, or a claim of sovereign immunity. So in other words, there's some dispute about whether this area is in fact a state. So this is what the court's going to start with to look at. Now I will tell you right now that this four-part test is not the end-all be-all, meaning you may have an area, they declare themselves to be independent, that's called a unilateral declaration of independence, one-sided. And they may meet this four-part test, but that doesn't mean they're actually really a state. We'll get into that in a minute. So this is like the threshold, if you will. So, a permanent population, a defined territory under letter B, a government, and the government has the capacity to enter into relations with other states. So that's the first place we start when we're determining, okay, is this actually a state for purposes of international law? Under Article 2, the federal state shall constitute a sole person in the eyes of international law. Now what that sentence means, and we use the United States as the example, we are a federal form of government, which is very common around the world. We see it all over the place. It's nothing unique to the United States. And again, a federal form of government is essentially sub-political units, like in our case the 50 states have agreed to create a larger umbrella government that will engage in large-scale issues such as international diplomacy. So this is where, again, Oregon would fail the idea of being a sovereign because it is part of a federal form of government. And that would be true of other federal, like Germany is a federal form of government. You have very different states in Germany. But as a whole, the country of Germany is the federal government, and that it would be the sovereign for purposes of international law. Now, Germany is even more interesting because it's part of the EU, which is an IGO, and we'll talk more about that later on how, is it truly a state anymore if it's part of an IGO? It gets kind of interesting. Okay, Article 3. The political existence of the state is independent of recognition from other states. Even before recognition, the state has the right to defend its integrity and independence, to provide for its conservation and prosperity, and to organize itself as it sees fit, legislation, administer services, and define jurisdiction. So this paragraph 3 is sort of the idea that the state may declare itself to be independent. It may meet that initial 4-part test, but other states may or may not yet have recognized that area as actually being a sovereign. And that may occur for various reasons, politically, economically, historical affiliations. And so, for example, maybe you have an area that has declared itself to be independent. They meet the 4-part test. And some states in the world, and this sort of depends on East versus West, Cold War kind of things. So, for example, Russia may recognize it as a state, but the United States does not, or vice versa. And those countries that are affiliated with the former Soviet Union may recognize it, but other countries that are more affiliated with the Western Bloc do not. So you have this, which has been a historical thing, this tug of war politically on whether or not an area is a state. Number 4, Article 4. States are juridically equal, and have the same rights and equal capacity in their exercise. So this sentence is a reflection of what I've been talking about with the idea of rule of law versus rule of force, how sovereign states, from an international standpoint, regardless of their size, have equal standing in international law, just like we do under our Equal Protection Clause, 14th Amendment of the U.S. Constitution. Privileges and Immunities Clause are treated equal, at least in theory. And the idea here, same thing, only on a global level. Now, the reason why this is important is this is intended to reflect the idea that states have equal rights regardless of their population and their size, their economic or military power, in terms of what occurs at the international level. So in a court, the idea is that regardless of the size of states, they are the same in terms of legal authority. Now, we all know that that's not factually true in the real world all the time, but in theory, that's the idea. Okay. Article 6. Recognition of a state signifies that the state which recognizes it accepts the personality of the other. In other words, once a state recognizes another state, it accepts that area, that state, as being a sovereign, having all rights of a sovereign, and then recognition is unconditional and irrevocable, meaning once you've recognized it under this article, you can't basically backtrack. Now again, this on paper, in the real world, that's not always the case. And we'll talk about recognition more in just a minute. Recognition of a state may be express or tacit. So let me explain what that means. Recognition is when other states acknowledge, agree, whatever word you want to use, that an area is now considered a sovereign. Express recognition, express means upfront, clearly stated, So express recognition is essentially along the lines of maybe the president saying, we now recognize this area as being a sovereign state, and we will treat it as such. And that may be done by a presidential proclamation, could be done by an act of Congress, or a combination. So that's express recognition, which really doesn't really happen so much anymore. It does, but not as much as it used to. Tacit means conduct, for lack of a better way. Implied is another way of saying that. And what this means is, even if a country does not expressly say, we recognize this area as being a state, but they engage in international treaty making, for example, which is one of the rights of a state, by the conduct of the states engaging in treaty making, even though they haven't said, we agree this is a state, you only engage in treaty making with a state. So your conduct implies that you recognize it as a state, if that makes sense. I need to go back to this word juridical. I forgot to talk about that. Where is it? Okay, the word juridically. I forgot to talk about that one. So the term juridical or juridically, that term is used quite often in both corporate law, in business law, and in international law. Also in nonprofit law. So juridical is legally formed, a legally formed entity. So we sometimes use the term juridical entity. I think I have a slide on that somewhere in there. And that is a term that refers to a fictional entity, a non-human entity. We as humans are all our own political entity, our own legal entity, our own economic entity, meaning we all have our own individual human rights, our own individual right to own property, to enter into contracts. If we are harmed, we have the right to sue in our name. If we cause harm, we can be sued in our name. That's considered to be, on a, again, theoretical level, a form of an entity, a human entity, a personhood, right? But we also, in law, have fictitious entities. And we have all sorts of them. So in the business world, we have corporations, C corporations and S corporations, limited liability companies, like Microsoft is a C corporation. The corporation itself does not truly exist in the real world, right? It's a virtual thing. It's an avatar sort of thing. It is fictional, but it has legal existence. Now what I mean by that is, Microsoft isn't a person, it is a piece of paper. It's a theory, kind of. I don't know quite how to describe this idea, but the courts recognize it as having its own existence separate from the owners. So you may own shares of stock in Microsoft or Apple or whatever. You're an owner, but you don't have it, the entity itself, Apple or Microsoft, is totally separate from your ownership. So the concept of a juridical entity is a fictional entity that has its own legal existence and, in some cases, its own rights. So a corporation can own property. If it's harmed, it can sue in its own name. If it causes harm, it can be sued. It has the right to enter into contracts in its name, to own assets, including land, shares of stock in other entities. So a corporation is one form of a juridical entity. Now we have other types of entities. A nonprofit, so all the Rotary Club International, the Lions Club, Elks Club, Red Cross, all the NGOs. Those are also a form of a juridical entity. They have their own existence. Later on, we're going to talk about IGOs, intergovernmental organizations. They are also a form of a juridical entity, as are unions, religious organizations, governmental entities like school districts, Western Oregon, are all forms of juridical entity. Now, the reason I'm making such a big deal about that is this is the idea of a juridical entity is the fundamental structure of how IGOs and NGOs are formed. And we'll get more into that a little bit later. But so I just want you to know what that term juridical means, because I'll be using it off and on as we talk about states and organizations. So that's where that comes from. Okay. Article 8, no state has the right to intervene in the internal or external affairs of another, and that really should be addendum, without the consent of the state. So this is, again, a sentence that sets forth the idea that a sovereign state is sovereign unto itself. Other states do not have the right to interfere. Now again, we have this whole idea of peremptory norms, which sort of, I believe, overrides that. But this is the idea that a state does not have authority over another state, primarily internally, and without the consent of the state. I'll just point out Article 10 real quick. Primary interest of states is the conservation of peace. Again, this is per post-World War I. We see this same sentence, or the same idea behind that sentence, throughout the United Nations Charter. When we get to the UN Charter, I'll show you what I mean. And this is an embodiment of that idea of rule of force should not be used except by and in drastic measures or by consent of the international community, or in the idea of self-defense, as opposed to the historical concept of conquest, rule of force dominates. So this is an embodiment of the idea of rule of law, that one of the primary purposes of international law going forward is to promote peace, again, post-World War I, when this was written. Now, we all know that that didn't obviously work, but that's still the idea today, even. And we won't really get into Article 11. So I have a test question over the Montevideo rules. So again, you might want to put a little sticky on this page or fold it over or something so you can refer to that 4-part test precisely under Article 1. And that's where we get the 4-part test. So let's talk about how that plays out now in the real world in terms of what we call recognition. Okay, back to page 53. I just want to show you something. This is a restatement of United States law. So we have the same 4-factor test that comes out of United States law. I'm not really going to, it's that 4-part test again, but we've embodied the Montevideo rules into our own law domestically. Now, why does that matter domestically? Well, contract law, for example. If I'm entering into a contract, maybe I'm Boeing, and I'm going to enter into a contract with another country or a territory to sell them aircraft. One of the issues that comes up, if you're a state, then you also have what's called sovereign immunity. And we'll get that in a few minutes here. But sovereign immunity is essentially the idea that a state is immune from being sued in the domestic courts in another country, except for certain circumstances. But to be able to claim sovereign immunity, you have to meet the definition of a state. And that's one of the things a court would look at, this 4-part test. So we have it both in form of convention, and then it has been adopted internally within the U.S. As part of that process. So let's talk now about recognition. Watch National Geographic. Love that too. All right. So declaratory doctrine and constitutive doctrine, which I don't really care if you know these two terms. I want you to know these phrases here. De jure, de facto. De jure, de facto. So these two terms are used commonly in law. De jure means of the law. And this is a phrase that means that, in the case of a state, that the territory meets that four-part test of the Montevideo rules as a matter of law. But we use it not just in international law, it's used domestically. And basically the term de jure means you meet, whatever the case may be, you meet the standard as set by law. The definition is a strict interpretation. You meet the definition of whatever the legal issue is. But in the real world, we also have this idea of de facto. De facto means what really is happening factually. So, how do I describe this? A territory may meet the definition of the four-part test, which means as a matter of law, they are considered a state. But if no other states actually treat them as a state, factually, then you're not really truly a state, because other sovereigns don't treat you that way. They don't recognize you. So even though you meet the legal definition, you don't meet the real world definition. That's kind of the concept I'm trying to get at. So when we talk about, and again, when we talk about international law, we're talking about how sovereigns interact with each other at the end of the day. And so, Oregon may say, okay, we're seceding from the United States, we're a territory, we meet the four-part test, we're going to adopt our own internal amendment to the Oregon Constitution to allow for international diplomacy. So maybe we meet that four-part test, but if other countries just ignore us and don't treat us as a state, then by law, de jure, we meet that four-part test, but in the real world, we don't. So there's always this idea of overriding everything, the reality of what actually happens, conduct. This is sort of a form of customary law. So de jure means you meet the four-part strict on-paper test, but de facto means you really are not really truly a state until other states acknowledge you and treat you as such. It'd be like I could declare myself to be a professional basketball player, but until I'm actually hired by a team, I'm not, right? Something like that. That's a really bad example, but you can have something on paper, but until it's actually followed. So in the real world, you really have to have both. You have to have, I think I have another slide on this. Yeah, here we go. Page 57. So de jure means according to the law, and de facto, that should say de facto, spelling error there, I just realized. Okay. De facto means according to the fact. So essentially when we're talking about recognition, we're talking about meeting both of these tests. Number one, you actually meet the legal standard of the test, the four-part Montevideo test. But two, you are actually treated by other states and recognized as being a state. So that's sort of the real-world component of this idea of becoming a state. Okay, so recognition, a unilateral decision by another state to acknowledge, this is page 55, the existence of another political sovereign. Once recognized and applies that the state or government is entitled to all of the rights and privileges under international law, being treated equally, entering into treaties, being part of an IGO perhaps, joining the UN, the other rights and obligations of states on an international level. Recognition is not always necessary expressly, is what I'm trying to get at with this sentence. Some states may not recognize, but others may. So for example, I'll give you Kosovo. which declared unilateral independence several years ago, still in dispute. Some states recognize Kosovo, others do not as a separate state. This actually went to the International Court of Justice, where they ruled that they met the four-part definition. And they're, for nowadays, they're pretty much recognized as being a state. But this is this idea where there's always politics involved. So forms of recognition, next page over. This is what I talked about earlier. Express or implied. Express recognition is a formal statement by whatever authority within the country to recognize another state and treat it as such. Implied or tacit recognition, actions that normally are done between state may be proof that the state has been recognized. So this may be entering into treaties down below here. Implied recognition, in other words, these type of actions between sovereigns. Entering into a bilateral treaty, two-sided treaty with another state, that implies that the state is being treated as a sovereign. Treaties can only be concluded or created by states. So by entering into a treaty, you have to be a state to begin with. So that is evidence of recognition when treaty making has been done. Engaging in diplomatic relations, which may be exchanging diplomats, ambassadors, having an embassy, or hosting an embassy from that territory within your own state. That's a form of recognition because diplomatic relations are reserved to, for the most part, states or IGOs and NGOs. Reception of letters, this is kind of old school. Participation in multilateral treaty making or conventions, participating in an international conference that is exclusive for states, another type of basic actions that imply statehood because those actions are only the type of actions that a state can engage in, or nowadays an IGO or an NGO, which we'll talk more about later. So what is the significance of recognition or not being recognized? Page 58. So this is not U.S. law. An entity not recognized as a state or a regime not recognized as the government of a state is ordinarily denied access to the courts in the U.S. That's one outflow. So you don't have the ability to engage in court activity, nor can a territory that is not recognized as a state be entitled to the property that may belong to the state located in the U.S. And you have no or limited sovereign immunity. So this number two, the property. So where this comes into play is when you have, this is where recognition is important domestically within the U.S. So let's say we have, again, a territory that breaks apart, like Czechoslovakia, Czech Republic and Slovakia, but used to be together under the Soviets. So you break apart, and now the question is, are we as the United States, do we recognize the Czech Republic as an independent state? Which clearly we do now. The country of Czechoslovakia, let's say, before it broke up, had property in the U.S., so maybe an embassy, aircraft, bank accounts in New York, stock brokerage and other type of accounts. They may have gold deposits on reserve, those kind of things. And so if you're not recognized as now being a state, you cannot claim those assets because you're not the recognized state. That's what this paragraph means. This also means you have no or limited immunity, sovereign immunity, which we'll talk about in a minute. So some other types of terms here, different phrases that are used. We talk about statehood. So an independent state, which is going to be your primary sovereign, that is no free from political control or other states, except by consent, that is treaty. We have dependent states, which have formally surrendered some or part of their political and governmental functions to either another state, or I should put, or an IGO, such as the European Union. And then we have this cool term here, inchoate. Inchoate. The word inchoate in law means not fully completed. We use that in criminal law when we talk about an attempted crime, like attempted murder is an inchoate crime. It was not fully completed. So inchoate means that there is some attribute that's lacked under the Montvideo four-part test, or other attribute for it to be a state. So it's not a fully formed state. This is often applied to a territory like such as Kosovo that is trending towards statehood and implication, recognition, but not fully there yet. So independent would be like the United States or other countries. Dependent, you've given up some of your rights, such as the European Union. I would call those dependent states because France and Germany and the other EU members have transferred a lot of their sovereign rights to the European Union, which is an IGO. We'll study that more later in the term. And then inchoate, not fully formed. All right, let's talk about sovereign immunity. Page 59. The term sovereign or state immunity. So this is a doctrine of law that we see both internationally and also internally, domestically in our United States. And this is the idea that as a sovereign country, one of the definitions of being a sovereign is no other country has power over you, within your territory at least. And as part of that, you are, from a customary international law standpoint, and also from just a practical de facto standpoint, you are immune as a country from being sued in the courts of other countries. And this is sort of, this has various different impacts. So the most real world impact is, if I want to claim that Germany has done something wrong to me, and I sue the country of Germany in a court here in the United States, the country of Germany says, we have sovereign immunity. The courts in the United States have no authority over us because we are a sovereign state. And so the courts basically have no authority over other countries, nor the assets that are owned by those countries. That leads to whether or not you can even file a lawsuit, which we'll talk more about in a minute. This also leads to the idea of sovereign immunity of diplomatic immunity. That is, when states exchange diplomats, ambassadors, diplomatic staff, that in order to promote international diplomacy, with some exceptions, those diplomats will be immune from local laws. So this is where this happens a lot in New York, where you got the UN headquarters, where you may have diplomatic staff. Maybe they go out and get into a car accident after drinking too much alcohol. It's a DUI, but because they're diplomatic staff, they may be immune from prosecution because they're diplomatic. They have diplomatic immunity. So that's another outflow of this. Now, where does this come from? I mean, why not give a court the authority over a foreign government? I mean, that would seem like, okay, well, that's, that makes it easy for people within your country to take action if they're harmed. Well, the theory behind this idea of giving states immunity is, number one, historically just a matter of practicality. I talked about this earlier. If we've got state A that gets sued in another country, and they say, you know what, your judges can say whatever you want, try and take it from me. And it goes back to just old school historical force, and there's really no way to enforce, a local court against a foreign government. It just was not practically, it just really couldn't happen. Fast forward though, also behind this idea of immunity is the idea that in the United States we have a three-part government: legislative, executive, and judicial branch. And within the United States Constitution, international diplomacy is solely under the purview of the executive branch. And so if you think about it this way, if a judge, which is part of the judicial branch, has authority over a foreign government in a court case, then that is essentially engaging in international diplomacy in a way, either negative or positive diplomacy. And so this is the idea that the judicial branch, that is the courts in the U.S., will give deference to the executive branch as having that sole authority to engage in international relations. So in the background, there's this whole idea of separation of powers and checks and balances that you kind of have to factor into all this. So one is practical, it's just a matter of, if I sue the government of France in a court in Dallas, Oregon, the government of France is going to say, we're not going to follow that, make us. It's just not really practical in a real world sense. So nowadays, under the doctrine of sovereign immunity, domestic courts must decline to hear cases against foreign sovereigns out of deference to their roles as sovereigns. That may include foreign agencies and foreign officials. So the next slide over, the effect of that is you can't sue a state in court in your country except under very limited circumstances. A state is not answerable to a court in another country for its official actions. This also plays into the ideas we don't want judges in a lawsuit essentially declaring whether a foreign government did something legally or illegally. That's reserved for an international type tribunal. So there's two types of sovereign immunity. Absolute sovereign immunity and restrictive sovereign immunity. Absolute sovereign immunity means under no circumstances can a foreign government be sued in a domestic court, nor under any circumstance are the assets owned by a foreign government subject to seizure, garnishment, attachment, a sale by a sheriff to enforce a judgment. Part of this idea of sovereign immunity is both whether you can even be sued, and part two, even if you were sued, are the assets of that government available to be seized, taken, to pay money that the court has said they owe. So absolute sovereign immunity is not really followed just as a matter of evolution of law, and I'll show you why in a moment. So now we have more of a limited sovereign immunity. Don't worry about these Latin phrases. Jury imperii, we're not going to get into all that. But I do want you to know this. So, a state is still immune, meaning it may not be sued, nor may its assets be seized, in cases involving situations that are a result of a purely governmental function. So that would be international diplomacy, that would be potentially military activity, things that are of a governmental quality. But for actions that result from activities that are not necessarily solely limited to a government, such as commercial activities, then a state may not be able to claim immunity because their actions are also the same type of actions that may occur in the private sector, essentially. So the best example I can give you of this would be a breach of contract. So again, Boeing, let's say, is going to sell a bunch of aircraft to Nicaragua. for Nicaragua to use in their international state-owned airline company, but it's not for military purposes, it's not diplomatic aircraft. It's basically the same as what we would have, American Airlines or whatever, but it's owned by the government. So it's a governmental airline, but it's for retail type activity, not governmental airline activity. So in that case, that's a commercial type of activity. And just because it's a government entity as the buyer, so let's say they don't pay Boeing, so Boeing wants to sue them, they would argue, hey, we're immune because we're a government. And Boeing's going to say, no, wait a minute, in this case, you bought aircraft from us not for government purposes, but for essentially what amounts to airline activity like you would have in the private sector. So that's where you see an exception to this idea of sovereign immunity. And I think I have it on the next page. Oh. Another circumstance where a state may not claim immunity is when it has waived its right to claim immunity. So this is typically going to be in the form of a treaty or a contract, whereby, like for example, if Boeing enters into a contract to sell aircraft to another foreign government, as part of that contract, they would include a paragraph that says, in any dispute arising out of this contract, the buyer, which is the government of the state of wherever, waives its ability to claim any form of sovereign immunity. So the government has expressly given up that right as part of a contract. This also occurs in some types of treaties or conventions where a government may join on to a treaty, and as part of the treaty there may be provisions that allow or waive the right to claim sovereign immunity in certain type of cases. So for example, later on we're going to talk about the International Center for Investment Disputes, which is part of the World Bank. And as part of joining on, if you want to get funds from the World Bank, you have to waive your immunity in certain types of cases if you're a foreign government. So basically what I want you to know is what are the two primary areas where a government cannot claim sovereign immunity, and they are when the courts have engaged in, or when the government is engaged in purely commercial activity. This is a cut and paste of the Foreign Sovereign Immunities Act. This is federal United States law. And I'm sorry it's so wordy, I need to clean that up a little bit, but basically summarizes this whole idea. Congress finds that the determination by United States courts of claims of foreign states to immunity, the jurisdiction of the courts would serve the interests of justice and would protect the rights of both foreign states and litigants, that would be people suing in a U.S. court. So under international law, states are not immune from jurisdiction of foreign courts insofar as their commercial activities. So that is a form of customary international law in a way, that purely what we would consider to be a private type commercial activity, a government cannot claim they're immune. In other words, they could be sued just like any of us. The other is when, this is the next page over. The other time, a foreign state shall not be immune from the jurisdiction of the United States courts when the foreign state has waived its immunity either explicitly or by implication. That is, expressly as part of a treaty or a contract, or basically they have impliedly waived, which would be they didn't raise it as a defense, which it gets kind of detailed. So there are two exceptions. Number one, when the action is purely commercial. Number two, when a government has waived its immunity. Otherwise, the court will throw out the case, and a country can claim immunity so that its assets are not seized, unless it's one of those two exceptions. So also, this is on page 63. Talked about this already, but just so you see it in print. If a state has sovereign immunity, then it shall be immune from attachment, arrest, and execution of its property in a foreign state. This is a matter of customary international law, which has been codified. So in plain language, what that means is if sovereign immunity applies, then the assets of the sovereign cannot be seized. So even if they, there may, and you see this all the time in lawsuits against various countries where they may have huge bank deposits in New York City. They may have gold deposits, and litigants want to go seize that to pay off whatever damages they've had, and then the court says, no, you can't take it because they're a government asset. Okay, now, very similar to sovereign immunity, this is sort of like flip side of the same coin, is what we call the act of state doctrine. And this is the idea of a domestic court should decline to exercise jurisdiction over a foreign state when the case involves an action that is the type of action that is a governmental action. So this is the idea that a judge, we're talking about if a foreign state is sued in a U.S. court. One of the questions the judge has to look at in whether or not to handle the case or dismiss it is to determine, is the subject matter of the lawsuit the type that you're essentially asking a judge to declare whether a sovereign government is doing something that is purely a governmental function. Because again, this goes back to separation of powers, because we don't want courts, including the U.S. Supreme Court, essentially declaring the action of a foreign head of state or whatever to be unlawful, because that is a diplomatic function, and that interferes with international relations, so it violates separation of powers. So immunity means you can't be sued at all, nor can you have your assets taken. The act of state doctrine is the idea that courts should first review a lawsuit against a foreign government to determine if they should even handle it, or if they should just flat out dismiss it and say this is a matter of international diplomacy, not a matter for the courts, and therefore under the act of state doctrine, the judge will dismiss the case. They're intertwined with each other, but they're technically two separate things. Okay, so where are we at here? All right, so let's move on to page 64. Start talking about intergovernmental organizations and IGOs. Okay. So what is an IGO? An IGO is an intergovernmental organization. I have it at number 2 on my list of international persons, states being at the top of the list, although the trend is towards IGOs. A permanent organization, so permanent meaning it has an ongoing presence, as opposed to an organization that is created for a specific purpose. permanent organization by 2 or more states to carry on activities of common interest. So United Nations, European Union, World Trade Organization, there are about 400 IGOs. Some are big, some are small. Some are very specific for their purpose. Some are regionally related based on trade or commodities. So any type of organization that has states as members is what we're talking about when we say an IGO. So an IGO can have legal capacity as this juridical entity if it's recognized in the same manner as a state. Now, what does that mean? That means, like, for example, the United Nations. As part of being an IGO, the member states of the UN have essentially granted to the UN state-like immunity. And this includes the immunity from being sued in domestic courts and also from having their assets seized. And part of that is also allowing diplomatic immunity for the activities of UN members and their diplomatic staff. This also goes into the idea of allowing the United Nations access to the territory, going into other countries as part of their function. So an IGO can take on what I would call a semi-sovereign-like quality to it, in a way, by, again, this requires the consent of the member states. And I just want to kind of give you this theme that I came up with on my own, but I call it I think I have a slide on this, page 67. Let's just talk about this because I don't want to forget to talk about it. So this is sort of the theme I'm leading up to. I call this the rise of the IGOs, kind of like Rise of the Machines and Terminator, right? So what do I mean by that? Post-World War I and World War II, movement from rule of force to rule of law. And this has been the idea, the theoretical idea, but also real world, that international organizations can play a role to help avoid wars and economic hostilities by trending towards putting together these permanent organizations like the United Nations that have as their core function or core theoretical function maintenance of peace and security on an international level, creating a forum where governments can bring problems to the international community to hopefully discuss rather than just start shooting it out. To also, and this is one of the theories of the UN, which debatable if it's fully functional or not, but basically the idea is to, instead of having individual military action by sovereign states against each other, that instead of having that, which has historically been the case, in order, so basically the movement of using collaborative military or economic sanctions by groups of countries under the UN rather than individual countries using their militaries. That's the theory behind it. And again, this came out of World War II. So when I talk about the rise of the IGOs, I'm talking about this trend that we've seen really post-World War II, where we've had this explosion internationally of organizations that have been created partly to help alleviate the possibility of war, partly to help create an international forum, partly to sort of act like a sort of a legislature to coordinate trade so that we can have the same rules, harmonization on international business law. And so we've seen this trend towards moving international law away from purely state-on-state diplomacy to diplomacy and international law creation through organizations. And I'll give you specific examples as we work our way through. Now, depending on which side of the coin you're on, this may be a good thing or a bad thing. A lot of people say, well, wait a minute, these international organizations basically have the function of taking away individual sovereignty and putting it up on a global level, like the World Trade Organization, very controversial in some ways, because essentially one way of looking at it is a state is giving up its right to legislate domestically because they have to follow international rules. And so that can be seen as a diminishing of sovereignty by being part of the organization. And to some effect, that's true, that the organizational rules can override domestic law. So there's this idea of organizations being the new trend. Probably the next step's going to be, are organizations above the authority of a sovereign? Currently, sovereigns still are the primary player, but we're trending towards eventually, we're talking decades or hundreds of years out probably, to where organizations are the primary source of government on a global level. If you watch Star Trek, have you here watched Star Trek? The Federation, right, of planets kind of thing. So, now Earth is considered not a bunch of different countries, but Earth as one government. So that's kind of this idea of the rise of the IGOs. Okay, so, sorry, I got kind of. So back to page 65, we talked about the rise of the IGOs. What is the legal capacity of an IGO? Now this will depend on the type of organization, but one of the capacities, again, very much like a sovereign state, is the ability to carry out diplomatic relations with other states